Good morning. We're just waiting for the parties to join and then we can get started. So just give us a couple minutes while we do that. Good morning for those of you just joining. We are waiting for the parties to join, and once everyone's on, we can get started. All right. I think we're just waiting for Mr. Castro to join, and then we can begin the hearing. Let's see. Mr. Castro, I see that you've joined as a panelist, but your audio and video aren't on. So when you get the moment, please turn that on.
Good morning.
Morning.
Good morning. I believe that's everyone. So I think we're good to get started if everyone else is okay with that. So good morning. Today is Monday, June 23rd, 2025. The time is 9:30 a.m. And this is a status conference, the matter of William Castro before the Massachusetts Peace Officer Standards and Training Commission. This proceeding is open to the public and we are convening remotely over Zoom, and the status conference is being recorded. The Honorable Kenneth J. Fishman is the presiding officer over today's status conference. My name is Lizzie Smith, and I'm the hearings administrator for the Post Commission, and this matter is now before Judge Fishman.
Good morning. If counsel simply state their appearances for the conference, please.
Good morning, Your Honor. Walter Jacobs for Mr. Castro.
Good morning.
Timothy Hartnett on behalf of the Post Commission.
Good morning. And Mr. Castro is present as well. All right, we're here for a status conference. We last talked on I think April, early April 9th, maybe something like that. And lots of things are going on. First of all, before I talk about this pending motion that the respondent has, I was interested on how you're doing on discovery.
Yes, Your Honor. I received a discovery request on the 19th of May. I had hoped to get it responded to it on the 30 days, but on Wednesday, I informed the respondent that I needed a few more days, and so I'm going to send him stuff this week.
Okay, so
I just needed a little bit more internal review before I could send it out the door. It's almost all there.
So you expect this week to get the rest of it out, Mr. Hartnett?
Yes.
Good. So the elephant in the room, as we sometimes say, is this pending motion for an evidentiary hearing relating to the suspension order. I have drafted an order. I actually hope to have it out a week or so ago, but I was out of the country. And essentially what I've done, counsel, is it occurred to me that I really can't evaluate whether to hold an evidentiary hearing and the scope of an evidentiary hearing until I know what was presented to the commission in support of the original suspension order. So I've drafted an order directing the division to provide me with that material. The other thing I'll also need, Mr. Hartnett, I don't think that I know we had some discussion about these issues the last time we were talking, but, and actually you gave me some guidance on why you thought a hearing wasn't appropriate on the motion, but there's now been an additional written motion presented by the respondent, and I wanted to give you an opportunity to file a response to the written response to that. So if I think my order talks in terms of 14 days to provide me with the submissions that were made to the post commission prior to the entry of their order of suspension. And then a certain amount of time, actually, I don't have it right in front of me, a certain amount of time to give you an opportunity to provide a response to the pending motion. Do you have any problem with either of those?
No, Your Honor. I mean, just from what I understand, I'm in terms of submitting, what I'm submitting is submitting to you. Is that in camera? Because these are things that we are claiming privilege on. So
No,
I just want to make sure
actually,
that's understood.
you're absolutely right. At least certainly at this stage, it's before we address issues of privilege and the like, it's in camera.
Okay.
And actually, I'll make sure the order says that explicitly.
Okay, thank you.
It's because the tricky part of this, assuming that I grant a hearing, is it's really more the scope of the hearing than it is the whether to have a hearing, whether you actually need, whether it's adequate, for instance, to see what was there, to see whether what was there on its face provided sufficient to meet the standard required for an order of suspension of, and all, I think, just preponderance of the evidence as opposed to the harder, more stricter standard for the ultimate decision in this case, number one. And secondly, to sort of figure out how you conduct a hearing, knowing that there's been lots of information presumably acquired since all of that took place through the parties' own efforts to discover these matters and gather evidence. And that's the kind of evidence, to the extent it's relevant, we'd be hearing at a final adjudicatory hearing on this. But this thing needs to be sort of addressed at a moment in time, if you will, when the respondent says, well, I should have had an opportunity to present my point of view before a suspension order issued, or in an effort to dissolve the suspension, if you will, and not to try the case twice. You know, it's really it's to judge something that already happened and what the record was then, and I have no record yet, and that'll help me define again the scope of a hearing if we have one. The second part of that will be to inquire from the respondent whether you envision, if you get a hearing, submitting written submissions of what you likely would have presented if you had had that opportunity that you assert you should have had, or you are seeking presentation of testimony and the like. And maybe I could start with that, Mr. Jacobs, to get a sense of that.
I think it's possible, Your Honor, to do it both ways. We're not opposed to having an in-person hearing. There would be video presented as part of the evidence. We believe we presented a lot of what would be the evidence in the 7-inch binder that we produced during the presumed preliminary investigation. But that was done after an investigation was done that Mr. Castro was not aware of, and after the summary suspension was done. We can also do it on the papers and take all the documents, if they're provided to us, that the commission had, because we believe the summary suspension that was issued, I mean, we know as a matter of fact that the basis for some of it is absolutely false. What we don't know for certainty, which is why we've requested documents from the Post Commission, is what information was truthfully provided to Post. We did do a FOIA request through the city, and we have obtained information of communications between various people in the city and various personnel in Post. And we have found out that information that was ordered by the mayor to be produced to Post, which Post alleged in the summary suspension letter was not ever done, was not only done, but ordered to be produced to Post. And that one of the police officers, the liaison to Post, indicated that to Post that he didn't want to produce that, even though he was ordered by his superior officer, his appointing authority, to produce them. What we don't know is whether Post had ever acquired them or not. To our understanding, one of the allegations in the summary suspension is that there was never an investigation done about this car pursuit, yet we don't know why no one ever called the mayor's office to ask, did you do an investigation? And no one called Mr. Castro when he was acting chief at the time. Was an investigation ever conducted? Nobody made, as far as we know, any inquiries, which is what we're trying to determine. But we have evidence and proof that orders were issued for information to be sent to Post, which would have made that allegation of Post moot. They would never have made the allegation. The investigation was conducted. It was ordered to be sent to Post. Post says it wasn't done. So my conclusion is either Post wasn't given the information at any time, which I don't know until I see what Post was given, or the letter from Post is not truthful. I don't know where that stands right now. I also know that part of the allegations in the summary suspension about Mr. Castro's involvement in either hiring or firing or certifying, one is statutorily just plain not true. He does not have the authority to hire or fire, and it is Post Commission that has the statutory authority to certify. So those are things there. We believe from the information we've gotten from some FOIA requests that these are carbon copies of what various personnel in the Lawrence PD were trying to allege against Mr. Castro, because we believe there was, and we have other FOIA requests that we've gotten information that show collusion between the organization hired by the city to help with the search for the new police chief, for which Mr. Castro was a top candidate, collusion between members of the city council and that organization. And we have communications from the former personnel director's phone and various police officers that they were trying to put their thumb on the scales to force the decision not to make Mr. Castro a candidate and to eliminate him as a candidate, which has severely harmed his reputation, his income, and his integrity. And yet we have all of that information. A lot of the information that I believe Post used in the summer suspension came from some of these people who were colluding to destroy Mr. Castro. Mr. Castro, when he was appointed provisional and then acting chief by the mayor, was directed to clean up some of the problems within the Lawrence PD. And he was trying to gather the information to get it to the mayor, to have an outside organization come in and do a thorough formal investigation of things where the balls were being dropped all over. And there has been massive kinds of corruption within the city, potential grant abuses, a variety of things that rise, I believe, to the level of criminal conduct. And the desire on various individuals was to eliminate him because he was actively collecting information that would jeopardize these officers' positions. We believe that what we don't know for sure is the interaction between members of Post and these individuals, whether they falsely submitted information. We believe they falsely and so insubordinately failed to provide information to Post, but we have some very worrisome communications that we got from our FOIA between members of Post and city council who are supposed to represent the interests of the city. That is their client. The chief executive, the chief of police should all be clients of the city attorneys. And there are communications with members of Post even raising the issue. We're getting into issues of attorney-client privilege here that raise really serious concerns. And I think we need to have these issues addressed because they are overriding. They are the huge elephant in the room here. And to date, as Mr. Hartnett indicated, I've received nothing to provide any information. But whether you want that to be submitted to you in a in-person hearing, we are fully prepared to do so. Or if you want me to do it in a written form, we're fully prepared to do so. We responded to the show cause in absolute good faith with significant detail and documentation. We take this matter exceedingly seriously because Mr. Castro has had his reputation destroyed. His career has been ruined. His ability to be the chief has been destroyed. His pension has been significantly damaged. There is multi-million-dollar damages to Mr. Castro. We take this exceedingly seriously.
So do you envision, regardless of the form of the hearing, that you should be able to make a case that relies on not only what was available to you at the time of the suspension, putting it, sort of placing it in that point in time, or that you should be able to present the wide array of information that you have acquired since that, through FOIA requests and otherwise, to address that sort of I envision. I don't usually get to see what was presented to the commission at that stage of the proceedings for all different reasons. Often it's not necessary unless it's been raised in the form that you've raised the question. But that, and there's a reason I'm asking this question, but you think, well, I ought to be able to present everything I've learned on behalf of my client in responding to this case to address the suspension issue as well.
Well, I think certainly everything that was known by post at the time the summary suspension was issued, whether that was justified. I need to know whether that was done in an open hearing, because there have been issues raised that post has made decisions. There was an allegation, I believe, a litigation, that they have done things not following the open meeting law. I do not know because I was not a participant. Mr. Castro was not a participant. He was not even advised that this was taking place. He had no opportunity to be heard at the time. So I think that we need to know what was presented to post, and then we need to know why was information that should have been available to post not presented, which would have perhaps led to an absolutely different decision by post. What we don't know is whether post personnel were used by individuals in Lawrence who are trying to avoid accountability for their misconduct as officers, sworn officers of law enforcement, and potentially subject to investigation for criminal conduct. We don't know whether they deliberately misled post personnel to get them to make incorrect decisions because of incorrect information they were provided, or whether it was provided and personnel at post have gone down a bad rabbit hole that shouldn't have been gone down. We don't know all these details, but we should be able to use whatever we know is the communications between post and these individuals in Lawrence, because we know from information we've gained that it was post. I mean, I believe post has the authority to order investigations and conduct investigations as part of its statutory charge. I don't believe they have the authority to communicate to city attorneys who represent a city entity and city executives, including the respondent, order them to conduct investigations without informing the appointing authority, who is the client of the city attorneys. There were, from what we gather, multiple meetings where issues were raised. We're not so sure this is ethically the right thing to be doing, yet they were doing it. We think that there may have been gross misconduct by the city attorneys involved in this.
Okay, so but hold on a second, Mr. Jacobs. And just in terms of my question to you, which is a little bit more limited, but I understand, sort of reading through the lines a little bit, between the lines, what you're saying. But I guess my question is, it sounds like what you're saying is, regardless of when we obtained information, you're saying we, meaning respondent, ought to be able to present any evidence that is responsive to whatever was presented to the commission at the time that the order of suspension was issued.
Correct. We would be looking to address.
It doesn't matter when you learned it, when you acquired it, how you got it, or anything like that.
I think so, unless Your Honor rules otherwise. But I think we would be.
I'm interested in your point of view. I'm not making a ruling. I'm just getting information from you.
Only being respectful, Your Honor. Yeah. My opinion may not be agreed to by Your Honor, and then I have to abide by your decision. we would be focusing only on the 4 square corners of the suspension letter. That's what we would be looking to do. The allegations that Post raised that justified an emergency summary suspension with no opportunity for hearing. What is it that Mr. Castro allegedly did? And we can show, we believe, that there was no justification for any kind of suspension at that time, let alone a summary suspension where he doesn't even have a right to be heard. And whether that involves misconduct of people in Lawrence, we're very concerned because we feel that action would have been taken in Lawrence against some of these individuals, but there's also a letter from Post saying to Lawrence, don't you dare take action against this officer. He is protected by Post. We believe that Post can only protect an individual because of communication by that individual to Post. People who file information with Post have a statutory protection in the statute designed to give them protection so that Post can do its statutorily mandated job. And we don't have any problem with that. But when those individuals commit misconduct unrelated to the actual communications with Post, they should be held accountable. They have been getting away with overt constitutional violations and other things because people are scared to challenge them because they're afraid they're going to get jeopardized by the Post Commission for violating that letter that was sent to the city by Post saying, leave them alone or else. That's very worrisome.
Mr. Hartnett, what do you say about this?
I mean, I'm a little confused here, to be honest. We're talking about staying within the 4 corners of the suspension, and that sounded like we were going to limit it to what was actually before the commission at the time, and that there's considerable conversation about things that literally happened a year later. So that's not, to me, that's not staying within the 4 corners of that at all. I think, but more importantly, I think if there is going to be any kind of hearing or review of the suspension order, the review of the suspension order at this stage is a review of whether or not it was properly issued. And whether or not it was properly issued is based on what's the information that, you know, existed at the time and what was presented to the commission. Is what it sounds like you're asking to see in the order. And I think that's fine, and that's standard. This isn't unusual. There have been people who have challenged suspension orders, but that review is very limited. If we're talking about a review as to whether or not the suspension should be lifted today, well, that's a very different thing. And it's both procedurally different and very substantively different. There we're talking about a range of all types of issues, which are the exact same issues that would be at issue in the ultimate adjudicatory hearing. And I think we run into that problem. It's also procedurally different because the procedure, if you want to have something lifted, the procedure for doing that is not to go before a single commissioner or someone appointed to deal with that. It's to go have a hearing before the full commission. And those have happened in limited circumstances, but even those are very limited. And they've been 15 minutes. We're not talking about full-blown hearings. So, you know, but I don't think
but focus
that's
on
not
your
really
point.
I don't think that's what's happening here. I think we're talking about a limited review of what happened when it was issued, and that's fine.
But so let's stick with that for a moment. And that certainly was my concept from reading what I've read so far. But if we learned from whatever was presented to the commission to find certain acts that were claimed to have been committed or omissions by the respondent, isn't that the 4 corners? I mean, why, if they have arguments that there were all sorts of reasons why that if they had had an opportunity to be heard at the time, they could have successfully challenged the efficacy and reliability of that information, and regardless of whether it's issues of collusion or bias or the other kinds of issues that Mr. Jacobs has been talking about, do you think if it had happened at the appropriate time, if you will, that the respondent would have been able to do that?
Well, I mean, it depends on what we're talking about. He's talking about facts that literally happened this year. So those certainly couldn't have been raised at the time.
Okay, but that's a good point. But beyond that, I mean, that's not all he's talking about.
Sure. I mean, if he wants to, you know, obviously we received information at a certain point, and if he wants to challenge the credibility of that, that information at the time, as if he were, he wanted to respond, that's fine. And there's, I don't think but that's a very limited thing, and that would need to be limited to what information he had at the time, not what information he has now. Then once you go into the information, we start talking about information you have now or new allegations that are very broad. Now we're talking about the defense, and now we're going back to the main issues. Now we're having a full-blown adjudicatory hearing is what we're having at that point. And I think that it needs, we can talk about a limited hearing. That's fine, but then it has to actually be limited. And I'm not sure if we're all agreement on what that means.
For me, it's a bit of a chicken and egg problem until I get from you what I'm now asking for.
Yeah.
It's hard for me to even define the scope without knowing. I don't know what kind of presentations are made and what form it's presented to, because that hasn't been something, a part of the process that a hearing officer is normally involved with. And of course, in this case, the chair happened to appoint the same hearing officer to deal with the suspension issue. So I need to consider that. But I understand what you're saying. And I must say, I'll be able to better respond to this notion of what the scope is once I've seen that. And that shouldn't be something difficult for you to produce to me, I would gather.
No, Your Honor.
That limited record, whatever that was.
I would just
go ahead, Mr. Jacobs.
My apologies. I didn't mean to interrupt.
No, that's right.
I am not arguing that I want a hearing on whether what the commission had put before them by staff was adequate to issue a summary suspension, because if that information is false or incomplete, that may very well that the commission may have also been misled by the misconduct in Lawrence. I am looking for the ability, which I believe it is Mr. Castro's right, to have the suspension lifted by a hearing before the full commission prior to any consideration of the overall issues of his certification on a hearing on the merits, just focusing on the 4 square corners of the summary suspension letter, the basis upon which the commission issued the summary suspension. We would defend those allegations and prevail, I believe, that the suspension should never have been issued. Now, it may very well be that the commission members are astounded by the information presented at that hearing and feel, had we known this, we never would have issued the suspension. I believe that is the whole purpose of asking for that suspension to be lifted. And I believe procedurally, Mr. Castro has the right to go not before, as Mr. Hartnett indicates, a single member, but for the entire commission to move to have the suspension lifted prior to the full evidentiary hearing. That will flesh out a lot of the issues related to that initial, the 4 square corners of that suspension letter, because we believe there was absolutely no basis for that summary suspension.
I got that. I don't need you to argue that part anymore, right? Not this point, but I understand what you're saying. So to your point, Mr. Hartnett, it looks like what maybe and sounds like you envisioned in terms of where we stand now in the process is a bit different than what the respondent and his counsel are envisioning. They are envisioning what you described as as an effort to remove the suspension after the fact and address the broader questions that have been raised, as opposed to did they have enough, did the commission have enough to issue the summary suspension in the first place based on what was presented to them. And if they went through that process, and if I ultimately agreed with them, isn't that really just a matter I would have to refer to the commission to address?
I mean, that'd be for them to review that and however they please. I mean, the procedures for
that's what I mean.
That type of thing are they're spelled out in the regulations, and they're different. and the standard is different, and it's just a
Right.
completely different thing.
But it sounds like that's what's being sought at this point. It's not sort of, I mean, I'm not going to qualify it. I mean, that's actually sounds what I'm hearing from Mr. Jacobs he's looking for is that process.
Yeah, and I mean, it would be up to the commission on how they want to handle that.
Right.
I would just note, based on historical, the ones I've been before are nothing remotely close to the scope or the extent that is being sort of suggested here. And I just want that to be, I'm just mean that in a sort of polite, I'm trying to be realistic here. And so everyone understands the expectations. I don't know how the commissioners will want to handle it.
Well, neither do
think
I.
that's important to note, that's all.
No, neither do I. I don't have a clue how they would handle it, but you know, I think Mr. Jacobs envisions getting the very same massive information that he would present to me in determining whether the suspension was appropriately given in the first place and met the burdens that were required at that time. He'd be presenting that information and even more to the full commission in order to get rid of the suspension now. Isn't that right, Mr. Jacobs?
Correct, Your Honor.
Yeah. So, and as I really sifted through the body of what has been submitted in response to the order to show cause in support of the motion for a hearing, that's what I started to appreciate was your goal. And it's in a way, from the respondent's position, it's almost a waste of time and effort. And time is important because he wants to address the suspension issue. I understand why now, and not wait for a final adjudication in this case regarding his status. It seems to me that if I dealt with the more limited issue, as Mr. Hart, you've described it, and I originally thought what we were talking about, as a practical matter, they'd be saying, well, that's all right. So you've made that decision and you've decided in the context of this point in time and this sort of limited review that the suspension the summary suspension is upheld. Then in any event, the respondent would say, well, okay, now I want to put the whole body of material in front of the whole commission and challenge and seek a removal of the suspension at this time. However short or abbreviated the commission may historically be dealing with that issue, that's up to them, not up to me. And what they'd be willing to receive from the respondent in support of that position would be up to them as well, I presume. I didn't see that really as necessarily my role is defined. I'm going to go back to the order from the chair pointing me to this aspect of it to try to get a better look at that. But as you say, it's in the statute and regs, so it's going to happen one way or the other. But I want to move the process along in the interest of all parties. And so why shouldn't I, Mr. Hartnett, do you think? Why shouldn't I be saying to the commission, well, now that I understand what the respondent is seeking to accomplish here, what they're really seeking to accomplish is a removal of the suspension at this point. And that's up to you. It's not the question that was directed to me. Shouldn't I be presenting it to them? Referring it to them, I mean.
I mean, that does make sense to me. That does make sense. That makes sense to me. I have read his previous correspondence that way too. You know, it's been a little confusing, but I do read it that way. Yeah, I mean, that's fine. However the commission chooses to handle that, we'll handle it that way.
And they may say, there's lots of scenarios. One, they agree with the respondent and they remove the suspension. Two, they don't, and they still refer back the question of being able to challenge for me to decide whether they you can successfully challenge what the strength of the evidence presented in support of the original suspension at that moment based on what was available to the parties. If the respondent had an opportunity to respond in a timely manner at the same time. So they might do that too. I could see that as a third option from them. But I really want to get, for your sake, really for more in the interest of the respondent, I want to make sure we get the ball rolling on this right away. And this is better defined for me. I still think that in order to make that final ultimate reach that conclusion one way or the other on my part, I really need to see what was presented, and I can initially at least do that in camera, what was presented to the commission initially. And I don't know if, I have no idea if it's the volume of material, but that's kind of irrelevant to, I guess, what I'm trying to accomplish here. But that kind of information is isolated. You must know what was transmitted to the commission initially, right?
Sure, I did it.
Yeah, you did it. Well, you could forget. If you're my age, you might not remember.
No, I do, and it's yeah, I do.
Okay. All right, so we're going to do that. I'll get the order out so it's well defined. I understand your argument, Mr. Jacobs, that says, well, how do we respond to it if we don't know what it is? So this in-camera aspect of it, I'm sure, and claims of privilege. But I don't want to talk to about that theoretically until I see what it is and what kind of information in there may be subject to privilege.
I have no problems with Your Honor reviewing it in camera initially to help Your Honor make a judgment call. I don't need to get that information at this stage. I think Your Honor can get that and make some preliminary information. We're not trying to breach anyone's privilege in what we're asking. Obviously, communications, when there's communication between Post and the city, there's not privileged when the communications are not involved. It involves people outside the clients.
Okay. Well, thank you. So let me just switch gears. When I was reviewing the material again for today's conference, I may have missed something here, Mr. Hartnett. In the final allegations of the order to show cause, despite the fact that this all seemed to have been initiated by virtue of the claims about the so-called car chase, and the facts relating to that, of course, are included in the order to show cause. But it didn't. If my memory serves me, and I haven't looked back at it, that which precipitated all of this doesn't seem to be separately alleged as a basis for action by the commission, decertification. Do you know what I mean?
I don't. I'm sorry, I'm not following.
Well, that's good because I'm not saying it very well. But let me just pull the order to show cause out. I have that. I have it in about 20 different places here. It keeps showing up, and material is presented, but just get to that real quickly. And I may be wrong about this, but let me just excuse me for a second. Here it is. Do you have the order to show cause handy?
I do, Your Honor.
Okay, Mr. Hartnett, good. So if you look for the very last part in the wherefore section of the order, page 10, it lists the order to show cause why the commission shouldn't find various things, and talks about alleged false statement in the police report, the petition, decisions regarding Lawrence Police Department personnel, etc., the conversation with Captain Guerrera, the alleged intimidation of a witness, generally not fit for duty, unprofessional police conduct that may escalate. No, maybe that's it. I was looking to see if the allegations are pretty specific in that list. And
I think I know what you're saying now. There's nothing on that list that talks about the actual
thank you.
violation of the policy, the pursuit policy.
Right.
And yes, that would be incorporated at least to some degree in the pattern of unprofessional conduct. But the violation of a policy itself was not something we'd be seeking to decertify him on. It was the subsequent actions, including the falsifying the police report and then the violations of the suspension.
Okay. Well, okay, and that's actually what I was trying to figure out when I was thinking about it.
Yeah, so I mean, it is relevant towards the pattern, but it's not itself a separate charge.
Okay. All right. All right. So, putting aside all these important aspects of this, are there any other matters that the parties want to talk about at this point?
I don't believe so, Your Honor.
Mr. Hartnett?
No, I just don't know what our next step is. And
the next step will be you'll get an order today
Mhm.
Requiring you to produce what you produced to the commission before the suspension, summary suspension was granted. And I will make a determination on whether we're going to have a hearing of a scope that's appropriate before the hearing officer or referring the matter to the commission on the broader issue of removal of the suspension. And let them decide that issue before we proceed. And the other thing that's happening next, of course, is that you're getting the discovery to the respondent this week.
Yes.
Right.
So,
All right. If it turns out that I think it's appropriate to have the more limited version of this hearing on the more limited question, then we're talking about if I will look for a response to the motion for evidentiary hearing, a written response, so that's on the record, and I'll include that in the order, and we'll schedule a hearing date if that's what I decide to do. If not, the process will be interrupted by the referral to the commission.
Understood, Your Honor.
All right, everybody clear on my murky way of describing this? And
Yes, Your Honor.
I don't mean to be facetious about it, but it is, there's a lot of different roads that you have traveled down on behalf of the respondent, raising a lot of issues, and trying to define when those ought to be addressed. It's been a bit confusing, and that's one of the reasons I wanted to see, starting with the potential scope of it, see what was presented to the commission initially. I think that's going to help sort this out for me. All right. Well, it's always good to have another date, so we don't. So I think we should just schedule it for a further status conference, but not too far off. And it may be, if the commission has taken the process, we may not need that conference at that day. But I'm thinking like a conference, 30 days out, something like that. Is there any, let's see, where would that take us?
Judge Fishman, 30 days out would roughly be around the week of July 21st. We do have the July commission meeting on the 17th. So if we wanted to schedule something after that, we may be in good shape of seeing whether the commission decides to take up the case.
That's a good. They're scheduled, Lizzie, on the 17th, you said?
Yes, and that's a Thursday.
Oh, okay, so let's do it the early part of that following week. Is there any limitation for anybody if we did say the 22nd?
I'm open the 22nd, Your Honor.
that's fine, Your Honor.
All right, and that works for us too, Lizzie?
Yes, so how about 9:30 a.m. on Zoom for July 22nd?
Yep, great.
That's fine.
All right. Thank you. I appreciate it. And
Thank
we'll
you, Your Honor.
communication.
Mhm.
All right. Take care.
Thank you,
Thank you.
Sure.